Welcome back to the Friday 5 for April 5th, 2024. My name is Andrew Ayers. I'm a business law and estate planning attorney with offices in Edina, Minnesota, and New York City. Let's take a quick look at 5 questions from the week in about 5 minutes. Maybe these are questions you've had before. Questions that come up in consultations and phone calls and other meetings with clients. Question number 1 this week. What purposes can I use my LLC for? So in this case, the client already has set up an LLC, and they set it up in 2023 in order to give them the extra time under the Corporate Transparency Act to file their beneficial ownership interest statement. So instead of having 90 days, they're going to have until the end of 2024. But in this case, the question was, what purposes can they use the LLC for? When you create your LLC and you file your articles of organization, there's often a submission you make that says, what is the purpose of your LLC? Sometimes you'll limit it to, let's say, real estate purposes or a sales purpose or something specific, a definite type of business. Most times, however, you're going to select any general business purpose or for any legitimate purpose. So if you've selected that category when you create your LLC with your state, then if you need to change the purposes for your LLC down the road, maybe use it for a different kind of business, you don't have to go back and change your filings with the state. However, if you have set up your LLC for a very specific real estate purpose, and now you want to create a tech company, you may have to go back and amend your filings. Question 2 this week. Do I need a contract for my 1099 workers? This is a very common question that comes up if you're running a small business and you're working with people who are not full-time employees, you're not offering them benefits, you're not paying taxes on their behalf, they're not W-2 employees. We call them 1099 contractors because at the end of the year, if you've paid them more than $600, you're going to have to issue them a 1099 tax form so they can claim the income on their personal taxes or on their corporate taxes if they're providing you services through a company. And the question from this client was, do I need to have a contract for these workers? The simple answer is you really should have a contract. You want to make sure that contract spells out their role, what they're being paid, how they're expected to work. You want to protect anything they work, if it's intellectual property for your company, if you're giving them access to your client lists, you want to make sure that those are protected. And you want to have a provision that says you're not paying their taxes and that they are to be treated as an independent contractor, a 1099 employee. So while you don't have to have a contract, it's very important that you have one though, because it's going to spell out all the roles that that contractor or that 1099 worker is going to play for your company. We want to make sure it's clear in case there's any dispute that they are in fact a 1099 worker and not a W-2 employee. Question 3 this week. Can one LLC own another LLC? So this is a pretty common question I get because we think that, somebody has to own the LLC. And sometimes we actually create almost like a cascade of an LLC owning an LLC owning an LLC. And occasionally we actually throw a trust in the mix so that your trust owns an LLC that owns an LLC. It's a pretty common tactic we use with small businesses, especially in the real estate industry. And what we're doing is we're limiting the liability of that lower level LLC to the property itself. And then we can have an LLC that owns it. So the simple answer is yes, one LLC can own another LLC. There's a lot of different ways that you can own your corporate interest, and that's why it's important to speak to a professional to find out what's going to work best for you. By using this layered approach of an LLC, owning an LLC, and possibly a trust in the mix, we can work with our accountant to limit the taxes and the liability that you're going to see as we step into each different level of the pyramid that we're working with. Question 4, is my handwritten will valid in Minnesota? So I had an interesting conversation with a client who has spent a lot of money on a lot of things, but not on an estate plan. Instead, what he and his wife had done is just handwritten what they considered to be their will, and they were wondering whether or not it's going to be valid or not. So in Minnesota, we have some basic requirements if we're going to sign a will. You have to be over the age of 18, and you have to be of competent and sound mind, so you know what you're signing. Presumably, they were able to check that box when they wrote up the will. Next, it has to be written. So they've got a handwritten will, that's written. It has to be signed, which it sounds like they signed it as well. But the challenge they run into is the final piece, which is that it has to be witnessed as well. And this is one of those challenges you often run into if you've downloaded a will or estate planning documents from a website. What they've done is they've mail merged your information into their forms, they've sent it off to you, and hopefully they got the instructions right, because the little pebble that I see a lot of people run into is they didn't have their will witnessed or it's improperly witnessed. Let's say they had their spouse be one of the witnesses. which if they're going to be the personal representative under that will, they shouldn't be a witness to the will as well. So your handwritten will may be valid if you followed all the different steps, but it's still good to check with a professional to make sure that you've got everything you need in that will. And if need be, let's create an actual will as part of your estate plan with all your other documents to make sure your legacy is protected. And question 5 this week, also going back to wills, what state should my will be drafted in? So in this case, the client lives in 2 different states. They go down south for the winter, they're up in Minnesota for the summer, and the question was which state should they be drafting their will in? And frankly, you can choose either state. It's really going to come down to where are you a resident? So in this case, the person is only in Minnesota for a few months each year. They primarily live down south. And so the answer was we should actually have the will drafted in the state down south because most of the time they're there. They're a resident of that state. And frankly, the laws of that state did not have an estate tax like Minnesota has. So it was also interesting to look at that issue as far as should we do our will in one state or the other. So if you're in one of these situations where you're bridging 2 different states and one has an estate or an inheritance tax and the other one doesn't, you may want to consider that when you're deciding which state to create your estate plan in. So hopefully you enjoyed this video. If you like it, you can hit the like button or the thumbs up button below. You can subscribe to future episodes on YouTube. You can submit a question at the link below. You can go to 𝙁𝙊𝙇𝙊𝙒 and we can set up a legal strategy session to discuss any of these questions or other legal questions you may have. It's Final Four weekend, first for the women tonight and Sunday, and for the men's basketball tournament on Saturday and Monday. So if you're a basketball fan, I hope you enjoy the tournament this weekend, and we will see you next week.